Hi guys, this is Bade Shaik and I am the one of the co-founder of Lexjuris. I completed my graduation in 2019 from Andhra University and then I started my practice. With my associate friend called Tejarka Chainulu, we started this law firm called Lexjuris. From this Lexjuris, we are providing the legal services, legal questions and legal information to you.
What is dying declaration? The term dying declaration is nowhere precisely defined in the Evidence Act. It refers to a declaration made by a person by way of signs, verbal communications, conduct, or writing soon before his death or while he is on his deathbed. Relevant provision. Section 32 of 1 of the Evidence Act talks about the relevancy of dying declaration. It says that a statement, whether written or verbal, made by a person who is dead or who cannot be found or whose attendance can't be procured in the court without unreasonable delay is relevant when it relates to cause of death. Essentials of dying declaration. Dying declaration must relate to cause of his death only or refer to circumstances or transaction which caused his death. The person making the statement, that is, the declarant, must be found dead after making of the statement. If such person doesn't die, the statement fails to fall under the category of dying declaration and it might rather be treated as statement under section 154 CRPC and 161 CRPC. There must be proximity of time in making of the statement and time of death. This is very important while deciding whether the statement is covered under this category or not. The declarant must be mentally fit, that is, conscious oriented, fully aware, and able to understand the aftermath of making his statement while giving the statement. It isn't always necessary that the fact of mental fitness be certified by the doctor. However, if there is a medical certificate to that effect, it proves to be more effective and efficient. Dying declaration can be made to any person: a doctor, a magistrate, police personnel, friend, or any other person. However, if it is recorded by a magistrate, that accords more reliability and authenticity. The statement must be complete and not vague. An incomplete statement will always leave a loophole and has more chances of being tempered. Thus, an incomplete statement will not be relevant. The declarant must be competent as a witness. That is, he must be capable of being a witness if he weren't dead. To see competency of a witness, refer section 118 of the Indian Evidence Act. It is not necessary that the declarant is under the expectation of death while giving the statement. Other points to be remembered. The concept of dying declaration is based on the maxim nemo moriturus presumptari, which means no one who is on the deathbed is presumed to lie. Dying declaration must be voluntary. The person to whom a declaration or statement is made or who records such statement is known as a scribe. As of general rule, hearsay evidence is inadmissible under the Evidence Act. Dying declaration is an exception to the hearsay rule. The courts must act with caution while relying on a dying declaration, as such statement is not direct but coming from a person who has either heard or written it. Therefore, there are odds of filtration or manipulation in the statement. Dying declaration helps securing conviction in cases like dowry deaths, etc., where direct evidence isn't available. The statement must be explanatory as to the cause of declarant's death. Such statement is admissible in both criminal and civil proceedings. A suicide note is an example of dying declaration. Signature of declarant isn't mandatory on the declaration, but It is better to reduce the statement into writing and get it signed by the declarant, as this reduces the likelihood of unnecessary exaggerations. Where there are more dying declarations than one, it is the duty of the court to analyze and scrutinize on which of the declarations it should rely and on which it should not. FIR and complaint as a dying declaration. An injured informant who gives information to the police as to commission of an offence and dies thereafter, such informational statement can be treated as dying declaration if it relates to the cause of the informant's death. In the same way, a complaint by a person can be treated as a dying declaration if he dies after lodging of the complaint and the complaint refers to the cause of his death. Relevant case laws. Queen Empress vs. Abdullah, 1885, ILR 7, all 385. This is one of the important case laws on the topic of dying declaration, in which it was held that there is no particular form of recording a dying declaration. It can be by way of gestures, conduct, or signs as well. Kushal Rao vs. State of Bombay, 1958, AIR 22. The Supreme Court adopted the principles laid down by the Privy Council in the case of Pakala Narayan Swamy vs. Emperor, which includes inter alia the following. A dying declaration is not a weaker kind of evidence. A dying declaration cannot be equated with a confession of a co-accused, as it may not come from a tainted source. Necessity of corroboration doesn't arise from inherent weakness of a dying declaration, but from the fact that in a particular case, the particular declaration not free from infirmities.
I hope you understand the video, and please subscribe my channel for more interesting videos.